As tax practitioners, we often get asked the question whether it's possible to make a transaction more tax efficient. Now, I think in simple language, we all know that that means is there a way to pay less tax? Now, there is case law to the effect where, if we look at the Duke of Westminster case, where the judge specifically said that taxpayers may arrange their affairs to pay as little tax as possible, and that case has been quoted in various South African cases. I think what taxpayers who want to do tax structuring just often forget when they look at that case is what the judge said is that you may structure and arrange your affairs in a way that you pay as little tax as possible, but it must all happen within the boundaries of the law. So our question for today that we are going to be looking at in Tax Break, your podcast for South African tax professionals and practitioners, is what are some of these boundaries that you need to consider when you are structuring and planning transactions? Before we go to that, I would like to remind you to rate the podcast on your favorite platform if you like the podcast, to please subscribe for it. Then you can get notified of the new episodes every week. And if there are some of your colleagues who you think would also enjoy the podcast, to please share the link to the podcast with them as well. Now, those of you who are regular listeners would know that I always ask to send me an email if you've got an idea for an episode. So I've got exciting news on that front. I've developed a podcast companion app where on the app you can send me your ideas privately or you can post them publicly. Your name wouldn't appear, but the idea would be there. And if it's posted publicly, then everyone else who also goes to the app can give it a thumbs up to say, but I like this idea. I would also like to listen to an episode on it. And that would then give me an idea as to what should the next few episodes be. So go and have a look at it. The app is at the link tax.pvdz.co.za/app, so app. You are, of course, still welcome to send me an email as well. My email address is in the show notes. So if you've got any questions or you need tax advice, then just pop me an email. Right, so back to our question. What are some of the boundaries that you need to consider when it comes to tax planning? So I guess if we look at the whole spectrum of boundaries or anti-avoidance type of provisions, on the one extreme there's a principle of substance over form or simulation. It's not limited to tax. It actually applies in other areas of law as well. That basically says that if you dress up a transaction to look like it is something, but your true intention is something else, then the courts will give effect to your true intention. So there's an element of dishonesty which makes it quite a serious transgression if you're looking at something where you are purporting the transaction to be one thing, but you actually intend for it to be something else. You disguise it as something else. So that's on the one extreme, the substance over form, where it's, as I say, there's an element of dishonesty involved. On the other side of the anti-avoidance spectrum, you've got specific anti-avoidance rules, like, for example, the dividend stripping rules, where it's the rule in the legislation that's targeting specific type of avoidance arrangements that you need to consider. Now, somewhere in the middle, if you are looking at the transaction that's not caught by a specific anti-avoidance rule, where you haven't disguised it as something else, we find the GAAR, the General Anti-Avoidance Rules. So those are rules that we find in sections 80(a) to 80(L) of the Income Tax Act. And this is one of the key boundaries or the key provisions that would set boundaries on what you can or can't do from a tax efficiency structuring perspective. Now, why are we talking about the GAAR now? It's not a new provision. It's been around for many years. But I think there is a recent trend, if we look at the cases coming before the courts, that show us that SARS is applying the GAAR. Now, there's 4 cases. I'm quickly going to run through them, but not through the detail. I think, again, if we want to go through the detail, each case would probably need an episode or more on their own. So there was an APSA case that went to the Supreme Court of Appeal. It dealt with quite a complex structure that had cross-border preference shares in it, loans coming back into South Africa, and the focus of that case was really, it was from a procedural perspective, dealing with the notices and what should or shouldn't be in the notice. Then there was a BCJ case. It was a tax court case that where the judgment was published in May last year, that dealt with a sale of shares and the resulting capital gain. That, if we look at the overall structure, it seems as if the capital gain vested in another entity rather than the beneficiary of the trust, where it would have been subject to capital gains tax. It wasn't. And the focus of that case was really on the adequacy of SARS's reasons for applying the GAAR. Then, September last year, September 2025, there was another tax court case. So with these tax court cases being anonymized, the taxpayer was called Taxpayer G. It involved the use of STC credits and then also the possible recharacterization of what should have been fees or remuneration into tax-exempt dividends. And I think if you look at the Taxpayer G case, what makes that quite an important one is that case actually focused on the substantive provisions of the GAAR. So if you want to look at case law that deals with those provisions, that is definitely a case to look at. And then more recently, the last one in the line of cases is the Erasmus case, Supreme Court of Appeal case, where the judgment was published in March 2026. Again, it involved the use of STC credits, and SARS then disallowed that and assessed issued the dividends tax assessment. The focus of that case was, again, whether SARS could post-assessment go and change the reasoning that they relied on to apply the GAAR. So a lot of these cases are still quite focused on the procedural side of it. Now, before we go into and discuss what the GAAR is all about, because that's really what I want to get to in today's episode, is to talk a bit about what is the GAAR about, what are the requirements, and what should you be looking out for if you are dealing with something that could potentially be subject to the GAAR. But before we do that, I think it is necessary to go into the history and the context of the provision a bit. So the GAAR was previously, it's been in the Income Tax Act for a long time, and it was previously included in Section 103, subsection 1. And there's a whole body of case law on that GAAR. Now, there were some perceived weaknesses and shortcomings in that provision, and it was replaced with the current version of the GAAR in 2006. And I think the important part of these cases that we are now seeing is that until recently, there wasn't that much case law on the new GAAR, but I think there is now a clear trend emerging to say, but there's clearly from cases before the courts, we can see that SARS is applying the GAAR. As I said, not all these cases deal with the substantive elements of the GAAR. Some are procedural, but the fact is they show us that SARS is applying the GAAR. And I think in that light, it's important to understand, even if it's only at a very high level from a podcast like this, to understand, but when does the GAAR come into play? Now, the GAAR itself is actually a very complex provision. I had the privilege of updating our chapter in the Silk textbook that I'm one of the authors on last year. And the more work and research I did on it, the more I realized, but there's a lot of nuances in how you can interpret or apply that provision. So the idea for today is not to go into all of those nuances, and I think they are also, to be honest, fairly fact-specific as to how you can or can't argue or interpret the GAAR in the case of a specific set of facts. So what I want to limit the episode to is to really highlight a few elements of the GAAR to sort of indicate what the triggers are for you to be able to know when do you need to go and look a bit deeper into the GAAR? Okay, so the GAAR has got 4 elements at a very high level. The first one is that there must be an arrangement. That arrangement, there must be a tax benefit arising from that arrangement. The sole or main purpose of the arrangement must be to obtain the tax benefit. And lastly, there are certain tainted elements described in the legislation. So one of those tainted elements must be present. If all 4 of these things are ticked off, so you've got an arrangement, there is a tax benefit, the sole or main purpose was to obtain a tax benefit, and there is a tainted element present, then SARS may apply the GAAR. And we'll talk about what may apply the GAAR would mean or not mean towards the end of the episode. Okay, so just a few pointers on each of these requirements. If we look at the term arrangement, that's defined in section 80 capital L, and it's quite a wide definition. So it talks about any transaction, operation, scheme, agreement, or understanding. So it's not necessarily something that's documented. An understanding could just be an understanding between parties as to what they will do or not do. And important, whether it's enforceable or not. So the term arrangement takes you very far, and I think most transactions would be arrangements. So in many cases, that's not the distinguishing feature of an impermissible avoidance arrangement that's subject to the GAAR. Then, if we look at the tax benefit, there's a definition to say that you must have, through this arrangement, there must have been an avoidance, postponement, or reduction of tax, which is a tax in terms of the Income Tax Act. Now, what it means to avoid, postpone, or reduce a tax, there's case law under the old GAAR on that. And essentially it means that you must be stepping out of the way of an anticipated tax liability. So doing the transaction or having the tax event that you've got, if you would have anticipated the tax liability and now you are stepping out of the way of that, you are likely looking at something with a tax benefit. So an arrangement with a tax benefit would then be referred to as an avoidance arrangement in GAAR terms. The next test is the purpose test, which basically says that the sole or main purpose of your arrangement must then be to obtain the tax benefit. And whereas the previous GAAR had a subjective test to say, but look at the intention of the taxpayer, the wording of the current GAAR, I think there is some disagreement between commentators, but I think if we look at the taxpayer G case, it's clear that where we probably are is that it's an objective test looking at the facts and circumstances to ask, but what would the sole or main purpose of the transaction be, with possibly still considering the subjective intention, a subjective test of what the intention of the taxpayer was. So it's a combination of those two things to look at all the surrounding facts and circumstances and ask, but what would the sole or main purpose be? There's also a presumption as to what the purpose would be in section 80 capital G that basically says that if there's a tax benefit, then it's presumed that the sole or main purpose was to obtain that tax benefit, and the onus is on the taxpayer to prove otherwise, which makes it very important to be able to prove, but why did you do this transaction in this way other than getting the tax benefit? And then there's the tainted elements. Again, I think with those things, the more we go into them, the more you realize, but there's a lot of nuance to this. Essentially what they are in a business context, if you've done the transaction that's not done in a manner normally employed for bona fide business purposes other than getting the tax benefit, or the transaction lacks commercial substance. Now, there's a lot of detailed rules and provisions behind when a transaction lacks commercial substance. Then the tainted element would be present. In a non-business context, it is you've employed, the transaction was carried out in a manner not normally employed for bona fide purposes, other than getting the tax benefit. And in any context, if you've got a transaction that has created rights and obligations that would normally not be created by parties dealing under arm's length terms, or the transaction or arrangement misuses or abuses some provisions of the Act, then a tainted element would be present. So I think, as you can already see from just this quick overview, it's highly fact-specific whether the GAAR applies or not. And it really depends on the detail of your specific transaction. So if all 4 of these conditions are met, the GAAR, you've got an impermissible avoidance arrangement. And the effect of that we find in section 80 capital B, that says that the commissioner may then do a whole list of things, which includes disregarding steps in the arrangement, combining parties, recharacterizing some of the receipts, accruals, or expenditure, or determine the tax broadly as if the arrangement was not entered into, or as if in a way that the commissioner deems appropriate had it not been for this impermissible avoidance arrangement. From a procedural perspective, how would you know if SARS is applying the GAAR? Section 80 capital J gives us the process, and it basically tells you that if SARS intends applying the GAAR, they need to issue a notice giving reasons, and the taxpayer must be able to respond to that. So this Section 80J notice is where a lot of the action in the case law is currently about. And then from the other consequence, so SARS would obviously go and determine your tax in under Section 80B, but the other consequence that flows from SARS applying the GAAR is that you are looking at an understatement penalty of 75% for impermissible tax avoidance arrangements. So I think if we can perhaps summarize what to take out from today's episode, is that the taxpayer has the right to structure their affairs to pay as little tax as possible, but there are some clear boundaries in the law aimed at these types of transactions that include simulation, substance over form, specific anti-avoidance rules, and then the GAAR. And I think if we can perhaps summarize the GAAR, is you need to, at least as a professional or tax practitioner, know these triggers well enough to identify them when you are possibly looking at something like this, to know when to go and look a bit deeper. That's it for today's episode. As always, I just want to remind you that nothing in this episode is intended to be tax advice. The podcast is for information purposes only. Until next time, goodbye.